I'm deeply sorry, and I'm trying to go through all the rungs of the ladder to complete not only this little junction here, but to get on the straight and narrow for the rest of my life, sir.
I understand what he said and what I did not believe, but go ahead.
Fair enough. Um, he's been in jail for the past 2 weeks, Your Honor. Other than that, he has been compliant with his terms of bond. He doesn't have any problem drug testing and confident that should the court allow him another opportunity, all of his future tests would be clean. And if you did believe his story about the pill, he would not take any of the pills that were not prescribed to him.
Is that still his story? Because I would just tell you, if that's still his story, I don't think I can trust him to release an adjournment.
Yes, Your Honor. We're seeing if we can't negotiate something verbally. If I could be heard on bond.
18, 2026, 9/8. Yes, that's fine.
Yes, Your Honor. Ms. Gaines was placed in custody a couple weeks ago. Ms. Ms. Gaines from our office has had a chance to speak with her. I can't. I believe it's clear to her now that following court orders isn't a choice, but it's something that she absolutely has to do. She's prepared to do that. So we'd ask the court. She has stable housing now, and so I think complying with any conditions that the court sets to ensure both the safety of the public and the that she appear in court and comply with any of the court's orders will be much easier for her to accomplish. So we'd ask the court to maybe reinstate her previous bond and allow her to be released.
Any response from the people? Amen. So first of all, Ms. Gaines,
Yes.
counsel indicates to me that you now understand you have to follow the court's orders.
Absolutely.
What happened the first time? Why didn't you?
Situations with my living and relationship I was in.
So if I were to release you, how do I know you're not going to just fall back into that and end up back here?
I'm not. I have a stable home now with family member.
That's different from where you were staying
Absolutely.
before?
Yes.
And I believe she would be local here in Ann Arbor, Judge, rather than.
You were on testing, right?
Yes. Well, that's fine. I mean,
No, were you on testing before you released?
no.
Yeah, that's what I was wondering. What were you testing before? Were you testing?
No.
So you didn't have any alcohol monitoring?
No.
I'm not seeing anything in my life either, but the people at this site would be asking for alcohol testing. Yes.
Trying to figure out, we issued a no bond warrant. I'm not sure. There's another case, that's why. All right. I got it. September.
11th.
It was a while back.
Yeah, so
What did that indicate? She's on some. You were going to community corrections previously, though, right?
Well, when I went to court the last time, they were saying that I had to but I never got released.
Your Honor, I have from my lovely coworker that she never gave it to community corrections, so.
She did, that's why she wasn't, got it.
They are request to screen public.
Okay, that's why I don't see. All right. Okay, so I'll adjourn it to the 18th. Well, I'm gonna change that. I'll adjourn it to the 25th. Previous bond is reinstated. I will indicate that there needs to be a scram tether prior to release. Yeah. Okay. So, no, it's okay. We'll get it together. With regard to the request for a change in her bond, I'm going to deny that request given the circumstances of this case. Her bond will continue. I will set this then for the 18th as originally set,
Thank you.
2026, 9 a.m.
Yes.
All right, thank you. Court calls the case People versus Maurice Boyd.
Not good people. I got, especially about the defendants, down on behalf of the boy, we are both approach. Thank you.
Maurice Deshaun Boyd.
Thank you, sir.
Because we're asking for an
You
adjournment.
know what? Good, Mr. Boyd was coming up with her. That's NASA has moved that fast up voting.
It's moving fast.
Word.
We had to slow down.
Yeah, okay. All right, what do we do?
Judge, we want to look into some treatment court options for Mr. Boyd.
All right. Probable cause conference then will be adjourned to 25th, 2026, 9 8. All right, thank you.
Yes. Thank you. God bless. Thank you.
Sure. Court does call the cases of the People versus Taiwan Griggs.
Folks, the people.
Michael Gaddy, Assistant Public Defender for Mr. Briggs, Your Honor. He's making his way into the courtroom.
You know.
On the 24 case. The order on competency?
Correct.
Okay.
The order of the meeting.
The order on the finding. All right.
Your name? Taiwan Grace.
Thank you, sir.
Yeah. Good morning.
All right. What are we doing?
Your Honor, I've submitted a green sheet. We're asking to adjourn this matter a couple weeks so that we can continue discussions with the people. And Mr. Griggs does have a hold out of Garden City. There is a release to treatment order in these files signed by Your Honor. He's got a hold out of Garden City that he's hoping to clear up on June 15th via Zoom. I did check the Garden City Court's website. There is an arraignment scheduled that day. It's a resisting charge, Your Honor, a felony. I don't know what their bond will be set there. I was going to ask the court, we have spoken to Mr. Griggs' sister who reports he can't stay with her if he is released. I'd ask the court to consider if he is able to clear the warrant in Garden City to consider a personal bond.
I won't consider it this time until we see what happens in Garden City. You're requesting an adjournment. Is the 18th going to be enough time for you?
Yes, Judge.
All right. Now I'll adjourn these matters to June 18th, 2026, 9 a.m. On the 2000, Mr. Gaddy,
Yes, Judge.
you've requested of Ms. Gaines, but on the 2024 matter, a corrected order on the competency finding
Okay.
to the court. And we need that today if we can get it.
Yes, Your Honor. I will see if I can't get that corrected.
All right. Thank you.
24.
Yes.
Is it possible to get a bond reduction?
All right. Thank you. Thank you, Mr. Grier. Court calls the case, People versus Nicole Bragg.
Anything added?
Morning, Your Honor. Ashley Hannibal for Ms. Bragg. Requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Davi Lebo.
I thought you were Cannon.
Cannon's not here today.
That's why it's been so quiet. Okay. So just between us, who do you like better?
Tough call.
No, it is.
I might
Like
have
her.
to go with Miss Cannon. Yeah,
What'd you say?
Cannon.
Really?
Yeah.
You gotta learn. The lawyer should have answered whoever is in the room. Cannon's not here. You should have said Lebo. You're not? I'm offended for you. Huh? Like
I
it?
don't think so.
Okay. Permission to practice is granted.
All right, thank you. We have not been able to get in contact with Ms. Bragg, and we would like to adjourn.
You would?
Yes.
Who told you to do that? Spo?
Yes.
I see why you like it better. He was putting you up here. You're to get set up because I'm not doing that, right? All right. I would note that there is also your client has a bond violation and has not appeared at community correction since release. So a bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately. Thank you.
All right, thank you, Your Honor.
Really shucks. Cannon better. That's that. I don't know. I would have picked Lebo. That's on principle, really. Court calls the case of the People versus Seth Cope.
Is that not here? We want to.
For the judge, Court shall feast first assistant public defender on behalf of Mr. Seth Cope, who should be approaching. When you arrive, Mr. Cope, please state your name for me.
Seth Cope.
Thank you. We are in the process of work on a global resolution. I believe Mr. Cope has a few other matters pending. We'd be asking for a brief adjournment.
So how much he's got other cases, obviously.
Judge,
How much time are you gonna
3 weeks, I would think, Judge,
3
please.
will work? All right.
Forethought.
You guys, a case of the 22nd for a UFP that was up yesterday and that bond denied, and we also face of working for talking with the same victim denied it today.
Got it.
I was just.
All right. And you're trying to work it up. Why don't I just do July 2nd, 2026, 9 a.m. See if it's all wrapped up.
Thank you.
Okay? Bond will continue. Thank you.
Since last year.
Go change that.
Court calls case People versus Aaron Brandon.
Okay.
And is that not here?
Michael Gaddy, Assistant Public Defender on behalf of Mr. Brandon, making his way up to the podium, Judge.
Aaron Brandon.
Thank you.
We are asking for
Yeah.
some exam and the next.
Oh, you're asking for
No,
what?
yes, Your Honor, we're asking.
Want a preliminary examination?
That's Judge.
Yes. All right. Discovery is complete.
To the best of my knowledge, Judge, I believe there's one already set. Is it next Tuesday? No, on a different matter, Judge. I'm sorry.
Okay. So he doesn't have another one set.
They're set for on a different cases of different victims. So these are two.
So he's got one set on the 9th or the 16th? 9th? Okay. But these are separate cases. All right. Then and so would the people have their witnesses ready in this on the 16th? All right. Preliminary examination will be set in person, 16th, 2026, 9 a.m. before me. Bond with its conditions will. Thank you. Court calls case versus Ryan Miller.
Assistant Public Defender Davi Lebo for Mr. Miller. Miller, could you state your name?
Ryan Scott Miller.
All right.
And Your Honor, firstly, with regard to the bond violation, Mr. Miller would admit to the violation for the syringe.
All right. All right. And what are we doing?
Now, so with regard to the probable cause conference, we'd ask to set this matter for preliminary examination. I would like to address this bond.
All right. Admits the violation. How long has he been in?
Your Honor, that I'm not sure if I can check. 9 days.
Well, if you,
9 days, Your Honor.
you want this set for prelim.
Yes, please.
All right. Preliminary examination will be June 16th, 2026, 9 a.m. before Judge Moore. As to bond.
And with regard to bond, Mr. Miller indicates to me that he believes the syringe was left in the vehicle by his girlfriend. He does tell me he's completed an assessment for treatment as of 5/27. He wants to do home new outpatient treatment. He does have a job interview.
Hold on a second. What about the meth?
Your Honor, I was only aware of the syringe. Unfortunately, I didn't receive a formal violation report.
Oh, no, he may now be admitting to other things, but when they arrested him, he alleged that he was in possession of methamphetamines and marijuana, violation of his bond conditions.
I got some charged with the marijuana, but there could have been some in there. I don't know.
What about the mess?
There could have been some. Yeah, I don't know what. They didn't tell me nothing.
So would you like to admit or deny that?
I'll admit it. That's fine. I mean, I just released the treatments. What
Thank
they're
you.
trying to do.
Your Honor, he would admit to the possession of the
That's
meth.
fine.
I would perhaps ask the court to take a pause on that just because there is a pending warrant request for the possession of the meth. And if there's going to be charges, I don't want them admitted
Oh,
to that necessarily. So
I would agree with that if they're going to be pending charges.
All right, all I'm gonna do is that, but he's not admitting. My report doesn't indicate anything about a syringe.
Yes, Your Honor. So we would retract that. That was what I was aware of.
So he's not admitting at this time to the violation.
No, Your Honor.
Okay. Then any request for change in bond or modification of bond is denied. His bond will continue. We'll just continue it to preliminary examination. All right,
Thank you, Your Honor.
thank you. Court calls case People versus Trevon Bridges.
Your Honor, ring the people.
Assistant Public Defender, John here. I can really, Your Honor, on behalf of Mr. Bridges.
Your name?
Can I for the record? Just for asking for an adjournment to continue negotiation.
Adjourn this matter to June 25th to 2026, 9 a.m. All right, thank you.
You just.
Court calls case People versus Justin Mosier.
Your Honor, ring the people.
Close.
The judge. State your name for the record, sir.
Justin Moser.
Thank you, Judge. We would like to request to adjourn this matter for further negotiations, and I believe my client would like to respond if possible, Your Honor.
Preliminary examination will be adjourned June 18th, 2026, 9 a.m. as to bond.
Thank you, Judge. You might recall we were here a couple of weeks ago.
I do.
At which point my client went over to community corrections to test. He believed he was
Yeah.
clean.
Yes, he did.
He did not come.
We all got a surprise.
Yes, we did, Judge.
Yes, we did.
It's Judge. Stated that he had taken an appeal he wasn't supposed to take for persistent back.
Yeah, I remember the story.
That's what he said.
Yes. Oh. And I understand what he said and what I did not believe, but go ahead.
Fair enough. He's been in jail for the past 2 weeks, Your Honor. Other than that, he has been compliant with his terms of bond. He doesn't have any problem drug testing and confident that should the court allow him another opportunity, all of his future tests would be clean. And if you did believe his story about the pill, he would not take any of the pills that were not prescribed to him.
Is that still his story? Because I would just tell you, if that's still his story, I don't think I can trust him to release it.
Is that still your position on how the test came back positive?
I took a pill and I knew it was an opiate pill.
Oh, so now we know it was an opiate pill.
Story had
And
changed.
it has,
Yeah.
and I'm 100% sorry. I would be more than happy to pass tests with flying colors, 2 a week, many you want to.
Oh, don't tell me that.
I think he means it, Judge. He did indicate on the phone call we had that he is the sole caregiver for his children and his mother. His girlfriend does work full time and she provides for the household. She's been struggling for the last 2 weeks as a result of his incarceration. He said he'll test and do whatever the court needs him to do, clean, and prove to the court he'll be clean if the court will give him another opportunity. So that's what he's asking for. Apologizes.
Why didn't you just tell me the truth at the beginning?
You know, sir, I'm scared like heck to be in the system. It's the first time I'm in this system, and I wish I was more forthcoming and upright.
Yeah, how'd that work for you?
It didn't work good, and I'm
Yeah.
fast about the system, and you're not playing around here, sir. So I'm learning very quickly, and
Okay, go ahead.
I don't want to incriminate myself any further. I'm sorry for what I've done. I'm deeply, deeply sorry, and I'm trying to go through all the rungs of the ladder to complete not only this little junction here, but to get on the straight and narrow for the rest of my life, sir.
Any response from the people?
I wouldn't have an objection to the court releasing him with some fairly strict testing requirements.
Everybody's so nice to me.
It's a good day, Judge.
So he's admitted to the violation.
Yes, Your Honor.
He did fine.
How long have you been in?
2 weeks, Judge. Two weeks, what?
Yes, sir. Yep, 2 weeks.
Oh, yes, sir. Got it. Oh, that's right. That's why. How many times a week you think if I release you, you should be tested so I can make sure you're clean?
Sir, I'll leave that determination up to you. I'd be willing to do 1-2 times a week, up to your discretion.
I said as many times before.
He said at least
When
one or I think
Go ahead.
that is at least 1 or 2, up to the court's discretion, up to the minute you think about it. So if you want 7, I think he's saying he'll do 7, Judge. What you're saying?
That's what I'm saying.
Drink?
No, sir. I have in the past. I'm not currently drinking.
I think what he means is
Okay.
I'm willing to blow. I'm willing to blow as well. Test for drugs and blow. So
I think what he means is he has
This is a confessional. It's not. Asking.
Have you had a drinking issue in the past? What judges ask?
I have drank in the past. I'm not currently drinking now, and shortly before this, I wasn't drinking as well.
What's your drug of choice?
Okay.
Is it drugs? Is it alcohol? Is it both? And so that's what he's asking you. Is have you had a problem with alcohol in the past?
Okay, what I'm gonna do in this case is I'm going to adjourn this out to the 25th as opposed to the 18th at 9 AM. Previous bond is reinstated. He admits to the violations. I will sentence him to 14 days Washington County Jail, credit 14 days served. I'm reinstating his previous bond of $10,000 personal recognizance. I will also order and signing a new order that defendant is to report to community corrections for 2 times per week testing.
So much, Judge.
Thank you.
Thank you, Judge. I appreciate it, Your Honor.
Don't let me down.
Don't mess it up.
All right. Yes, sir.
Thank you, Judge.
I'm impressed by me. Or calls the case. I'm being like. It's like a Moses thing. Just sorry. Court calls the case people versus Donovan Buckner.
Where? Assistant Public Defender.
Mr. Buckner, can you state your name, please?
Donovan Logan Buckner.
Thank you.
So, Your Honor, we're asking for an adjournment. We had not been able to contact Mr. Buckner. He did call our office today. So, Ms. Buckner, can you call back to the office and ensure that we have a good telephone number for you?
I did contact the office last week. I believe it was last week.
Okay.
I updated my phone number and email with the office.
All right. Could you do that for me one last time?
Can you do it one more time for us? Well, not for us.
Yes, ma'am.
I think that was for you. No, we're
Not the ma'am.
no, they're not. All right. All right, do that. I'll adjourn this matter June 25th, 2026, 9 AM. Bond will continue. Thank you, sir.
Thank you very much, guys. Have a good day.
You too.
Adjournment.
Hey, you find Banbury? No. Never mind. I'm not calling it yet. Trying to keep you honest. Court calls case People versus Kenneth Perry.
We're over.
Got it. Mike.
Assistant Public Defender Jay Bellinger on behalf of Mr. Perry. Perry, can you please name for the record?
Kenneth Perry.
Thank you.
Your Honor, my understanding is that we're asking for additional time for negotiation purposes. Is that your understanding as well, Mr. Perry?
Yes.
Probable cause conference will be adjourned, what, 18th or 26th?
I think 18th would be sufficient. Who's on?
18th, 2020, 9 AM, bond continued.
Thank you. We'll be in touch, okay?
What about bails?
Your Honor, may we briefly address bond?
Go ahead.
50,000 working. Where can, that wasn't the question. Where can
You may want to, Mike, but
this one?
no.
No, this one. Thank you.
I haven't been able to get my phone to get numbers to call people.
Okay, but that's not the question. Where can you stay?
No,
Okay.
I'll just forget. Yeah, so.
Well, no, I didn't say that, but Your Honor, my client is certainly seeking a reduction in his bond. My understanding is that he his bond is currently set at 50,000. He can afford to post 1,000. He advises that he currently doesn't have many options in terms of where he might be able to stay. Part of the reason is because he doesn't have a phone currently on him. I believe it's being held in his property. So upon release, he would be able to make contact with some individuals to see if he might have a place to stay at that point. He's willing to do GPS tether. Any other conditions as set forth by the court.
Front.
I think the defendant's bond is appropriate as set in this case. The defendant and the victim are roommates. He woke up to him her genitals over her clothes and was able to text 911 for help. He admitted to touching her in her sleep. He also is a convicted sex offender, has failed to comply with those reporting requirements, and has some additional convictions, including domestic violence and 2 OWIs. So I have concern for community safety, and also that might be like
Over 10 years ago.
Anything else?
Nothing further, Your Honor.
Motion for bond reduction is denied. Bond will continue.
We will be
Thank
in
you.
contact.
Courthouse case people versus Aaron Burrows.
people you're on it.
Ready, Judge?
Well, it's good job. You have
Mr. Aaron Burrows. Your Honor, I believe Mr. Burrows may have been present earlier, but he does not appear to be here now. I don't know what.
What?
He may have been present earlier, but he does not appear to be here now. I don't know if something may have occurred or came up. For
Like his knowledge of a community corrections bench warrant?
totally possible, Your Honor. So for the record, I request an adjournment, but I do not know why he is no longer present.
I would just note that it also goes here on 14th of May.
Yes. Pardon? He currently has a community corrections bench warrant for violation of his, believe his testing or the requirements of community correction. I'm going to leave out the corrections bench warrant. That bond is set at no bond.
Thank you, Judge.
Thank you. Courthouse case, People versus Arnold Preston.
There it is.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Preston, who's making his way to the judge.
Your name, sir?
Arnold Preston.
All right. What are we doing?
Your Honor, there's some outstanding discovery. I did have a chance to speak with Ms. Willingbringham. We're asking for a brief adjournment so we can obtain that. They'll probably need some kind of protective order for it.
I just have a protective order to this over Mr. Gaddy. Well, just need to sit in front of before I could send it.
June 18th, 2020.
Thank you. May I be heard on bond, Judge?
Right.
Thank you. Your Honor, Mr. Preston's here. He was arrested, I believe, around Memorial Day on these matters. The allegations stem from allegations made in 2022 or early 2023. I don't believe that he's a flight risk. He does live in Michigan, up near Baldwin County, Gladwin County. My mistake. Yeah, he is gainfully employed. He lives with his mom, and like I said, he's been employed for the last 3 years. He is. I believe his job is still there. I don't think there's any issue with any kind of a no contact order. I don't believe complaining witnesses even in the state at this time. And like I said, I think he pulled over for a traffic infraction, and that's how they knew about the warrant. I don't think he even knew about the warrant, Judge.
At $50,000. The allegations are sexual assault against his biological daughter. They are stemming from 2022. Defendant is already convicted sex offender, has failed to comply with those reporting duties at some point. Has a CSE pre-conviction from 2012. These are also charged as CSE second offenses with a mandatory minimum of 5 years. So I do have safety concerns, given a prior CSE conviction and the accusations that made in this case would ask bond release.
Motion bond reduction is denied. Bonds continue.
Thank you.
Thank you.
Your Honor, My apologies. I didn't catch the adjourn date.
The 18th.
Thank you, Judge.
Court does call the case of People versus Rodney Clark.
Good morning.
Back.
Ashley Hannibal for Rodney Clark, who I believe she's joining us on Zoom.
Still don't like Lebo?
Oh, wow.
Second.
We'd like to adjourn to discover.
Hang on. Hello, Rodney Clark. Thank you.
All
What would
right.
you like to do?
We'd like to adjourn to review discovery with Mr. Clark.
Probable cause conference in this matter will be adjourned June 25th, 2026, 9 a.m. Leave him alone.
Thank you, Your Honor.
God. She was doing just fine. Bond continued. Court calls case People versus Martez Richards.
Allison on behalf of the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Richard to approach us. Oh, they didn't know how to use these. Mr. Richard, can you state your name for the record, please?
Martez Richards. How you doing, Your Honor?
I'm doing well. Thank you, sir.
Welcome. Let me see if I can get a telephone. No.
That's not what I asked.
Oh, say it again.
Do you want to set or do you want for negotiation?
It's just
Set for a preliminary examination or for negotiations. This is what I talked to you about yesterday.
Okay.
What would you like to do?
Is there any chance I can get a telebond today?
Okay, that's not what I asked.
I'm sorry.
no, you guys go ahead. Let's take all day.
Your Honor, may I address Bond briefly so that we can get that part over with so that we can then make a decision as to what he wants to do?
I was trying to see because I'm trying to get a surgery on my shoulder and on my wound and everything. And then I just had my daughter last Sunday. I haven't saw yet. And my autistic son about to have a graduation. So I was trying to see if I can get a tether bond or anything because I'm definitely gonna come back to court. And I'm not homeless anymore. And I completed my detox program and everything also. So me, I'm with sober living also. So I got transportation.
So here's the problem.
Okay.
This is why you have an attorney to try to put all of these things together. You got a very good attorney.
Okay.
And you decide to talk for yourself. You can talk for yourself if that's what you want to do.
No.
But it's not put together in a posture in which at this point the court wouldn't even consider changing your bond. So I'm going to deny any request for bond reduction. How much time did you need?
I think that we are in resolution talks, Your Honor. I think that we can have this resolved within 2 weeks. I would be asking for an adjournment to that date,
June
June 18th.
2026, 9 a.m. As indicating the bond will continue.
No, that is
Reduction
next.
9. Thank you.
So there's no way I can get out on tether or anything?
Anybody else understand what I just said?
Thank you, Your
I'll
Honor.
let your attorney do his job. Bye. Court calls the case People versus Deborah Collette. Oh no. Bad. Do you have a client this time?
Assistant Public Defender Zach with and on behalf of, but I see her right.
Oh, all right, fantastic.
Ms. Collette, can you please state your name for the record?
You need to unmute, Ms. Collette.
Mute. Okay. Hi, Your Honor. My name is Deborah Joanne Collette.
Thank you.
Your Honor, we are seeking an adjournment in this matter. There was discussion, I believe last time, of getting her into the 19th District Court Variety Court. Despite an initial indication from them that they did have space, they have since 3 different attorneys in our office have sent them multiple emails. She has called them multiple times, left messages. We have heard no response. So at this point, we fear that that avenue may be closed off. So we'd be seeking an adjournment to try to find another solution.
June 25th, 2026, 9 a.m.
Thank you, Your Honor.
Okay, Ms. Colette, we'll see you then.
Yes, sir. Thank you, Your Honor. Have a good day.
You too. Court does call the cases of the people versus Robert Shelberg.
Assistant Public Defender to not carry out ruling on behalf of Mr. Robert Shelberg. Mr. Shelberg, state your name for the record, please.
Robert Gerald Shelberg.
Oh, thank you. Your Honor, we're gonna ask for an adjournment. I think the court should have that. Is that right?
I do have surprise.
Asking for an adjournment, Your Honor. The people provided us with some information that I need to speak with Mr. Shelberg about.
You may.
Shelberg has been calling the victim's number that we have been contacting. In these calls, he says things like, "It was, I'm so sick, I can't even take it. You gotta get that taken care of. You gotta be here on the 4th to rebut it. You have to rebut it. You understand? You have to complete it. I'm going through it so bad. I've never went through withdrawals this bad in my life. You know they're going to give me a year. I'll never put you in this position again. I promise. I promise we're not going to go through this again. We're getting married. But if the third sticks, I'm going to prison. If you're there and you say he never hit me, he never put his hands on me." And I mean, it goes on and on. The forfeiture of the potential and intention to charge and it's for just these calls alone. So at this point, I'm going to be asking for his phone privileges and text privileges to be revoked, given that he's been contacting the victim numerous times and telling her to change her story and to not come forward.
What is his bond currently set in?
Your Honor, I have his bond currently set at $10,000 cash surety on the ED case and $25,000 cash surety on his controlled substance possession case.
Anything you want to say?
Nothing, Your Honor, until we're able to get those calls and review them for ourselves.
This time defendant's phone privileges and texting privileges are hereby revoked. I'm also given the substantial nature of those calls, the content of those calls. Defendant's bond is also ordered revoked. Defendant, you can go back.
Is that bond revoked on just the TV case?
It's revoked on both cases because he's not following. I didn't give one to 18th.
618?
618. All day, Janaza. All day we've been setting. What are you looking at the calendar?
I've been 25. I've been getting 25th yet.
Court does call the case. People versus Napoleon Corbett. Come on.
Good morning, Your Honor. Ashley Hannibal for Mr. Corbett.
They here? We don't have them.
All right, we'd like to adjourn.
Would you?
Yeah,
Yeah, I need the client to do that. You don't have one.
he is currently in custody in Wayne County.
Oh, probably should have led with that.
Probably should.
Is that what the people see also, or?
I don't have it right in front of me, but I will say.
Why? Why is everybody playing so nice? I don't. Fine. I'll adjourn it. Do you have a green sheet?
We do, yeah.
We're just gonna hold?
Yeah. All right.
All right. Do you have any? Where are you going? Come back up to the. Do you, like I survived. I'm just trying to get out. Do you have any idea when it might be released from?
I'm not sure. Okay. I see he has
You got it.
Yeah, I see he has a sentencing scheduled for the 18th.
You could have done that all on your own. So. You bet it. I'll adjourn it to the 25th.
All right.
All right. Bond will continue. Thank you. Court calls case People versus Gary Thomas.
Marshall Feaster, first assistant public defender on behalf of Mr. Thomas, who should be approaching. Mr. Thomas, when you arrive, please state your name for the record.
Gary Thomas.
Thank you, Judge. I believe Mr. Thomas did speak to our staff, and he did indicate that he wants to set this matter for preliminary examination, please.
All right.
Discovery is complete.
Discovery is complete.
I believe so, Judge.
Still saying all of it. Say right now.
Oh,
Within 2 weeks.
If we set for examination. See.
You'll have it by that point.
that's what it sounds like, Judge. That's
So you understand that if that doesn't arrive, he would not entitle to an adjournment.
fine with that. Yes, sir.
All right. So people would have their witnesses available the 16th.
We'll do it. Sure.
Preliminary examination, June 16th, 2026, 9 a.m. for Judge Moore.
Thank you very much, Judge.
Yes. Court calls the case People versus Castilian, Cotton Roberts.
And Assistant Public Defender, tonight we carry out the Your Honor, on behalf of Mr. Tiggio.
Castellion Cotton Robertson.
Castilla. Your Honor, we respectfully request that this matter be set for preliminary examination. All discovery is complete to our knowledge.
Want that on both cases?
Yes, please.
All right. People will have their witnesses available the 16th. Preliminary examination on both cases will be set in person, June 16th, 2026, 9 a.m. before me. Bond will continue.
Thank you so much, Judge. Okay, bye.
Court calls case People versus Larzell, Washington.
Assistant Public Defender, Chinazi Kyriakin-Rulli, on behalf of Mr. Larzell Washington, who is approaching. Mr. Washington, state your name for the record.
Larzell O'Neill, Washington.
All right.
How you doing, son?
Good afternoon.
Judge, the court should have a green sheet. We're asking for an adjournment. Mr. Washington we discussed the matter. We're trying to see if we can get an agreement from the people.
In the matter, June 18th, 2026, 9 a.m.
Okay.
Bond continued. Thank you.
Judge.
Thank you, sir.
And thank you, sir.
Court calls case People versus Riley Everett.
Your Honor,
Assistant Public Defender Donzie Leba on behalf of Mr. Everett.
Okay. Riley Everett. Thank you.
Andrew, I'm going to be requesting an adjournment. I think we're probably towards the end of this discovery discussion, but I do still need to continue discussing it with
Probable cause conference, June 25th, 2026, 9 a.m. Bond continues. Thank you, sir. Court calls case People versus Justin Heath. Read. State your name.
Justin Heaton.
All right. Mr. Heaton, you're here without counsel. First question I have for you is, do you wish to be represented by counsel?
Do I have a standby attorney?
Pardon?
Do I have a standby attorney?
I'm not going to grant you a standby attorney. Do you want to be represented by counsel?
Today at this moment, no.
Okay, are you sure about that, Mr. Heaton? And let me just tell you why, because you, um, you have another case. It's really not in your name, but about the place that you live. You know that? An eviction case? All right. Um, did you talk to an attorney, Travis Gagne, at all? Travis, you remember him?
Not that I'm aware of.
Pardon?
Not that I'm aware of.
Okay. Do you remember the police coming by your place that you live and talking to you? Mr. Heaton, listen, I mean, you have the right to represent yourself. I don't, I can't force you to get an attorney. Do I think it's in your best interest, given everything that I know? And usually I don't know all of this about people's cases, but I think it might be in your best interest to have one. But if you don't want one, you can continue to try to represent yourself. Okay.
Can I speak with an attorney before I choose for them to represent me today?
Okay, that's progress. Let me ask you this. Did you meet with somebody from CMH already? Do you know? Did somebody come and talk to you about treatment or anything? That would have happened maybe yesterday? You don't remember that?
I'm choosing not to respond to that.
Okay, no, that's fine. You don't have to. I'm just trying to figure out what, because part of that relates to the other case. Okay, that's why I'm asking. I'm not. All right, so let me ask you this, Mr. Eaton. You want to talk to somebody before you decide? So if I sent you back and let one of the public defenders come back and talk to you, you'd talk to them at least before we go ahead? Mr. Heaton, that's kind of, hang on, you don't have to respond to me. That's kind of what you asked me to do. So what I'm going to do is I'm going to ask them to take you back. I'll send somebody back from the public defender's office, talk to you a bit, and then we'll bring you back out, okay?
All right.
All right, thank you. Guilty to the charge of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand all of that, sir?
Yes, Your Honor.
And understanding that, do you still wish to, I should tell you this also, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Fleischer in the 14A3 District Court. You understand that, sir?
Yes, Your Honor.
All right. You still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed or had cause signed on your behalf of an advice of rights form?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Looking at paragraph 5, those are your rights which are part of a trial. You understand that you're waiving or giving up those rights as well as all the rights on that form?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of December 19, 2024, at the location of 6405 Jackson Road in Scioto Township, Washington County, State of Michigan, what'd you do that makes you think you're guilty?
Endorsed the fraudulent check and left with items from Menards.
Okay, so you went to Menards, you endorsed a check you knew was not good, and then you left with items that you would have had to purchase but didn't really purchase from Menards?
Yes, Your Honor.
All right. And was the amount of the merchandise that you got, was that in excess of $200?
It was $800, Your Honor.
Okay, so that's more than two, right?
Yes.
Okay. Sir, if I accept your plea, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand all of that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing will be July 6, 2026, 9 a.m. before Judge Freshour. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Mr. Pence.
Thank you, sir. Yes. Court recalls case, People versus Banbury.
Assistant Public Defender Zach Finu, on behalf of Ms. Banbury. Is she here now?
Not.
And Your Honor, my attempts to contact Ms. Banbury were in vain. We would ask for an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 cash surety.
Understood, Your Honor.
So immediately. Thank you. Court calls case, People versus Clarence West. Oops. She's a journey. Journey.
Hi, Mike. Oh, defense.
Your name, sir?
Clarence Alexander West.
All right. And Miss Akinruli, they are beginning I think it might be a separate investigative process regarding this case. She's requesting an adjournment of the proceedings. Is that correct, Mr. Gay?
That's my understanding, Judge. Yes.
Probable cause conference will be June 18th, 2 weeks out, 2026, 9 a.m.
Here she comes.
Okay, sir. Oh, there she is.
18th, okay.
Oh. So I'm right there. Oh, we're not doing this.
No, for PCC.
Yes, all day.
Bond continued. All right, thank you, sir. Court calls case, People versus Gregory Huff.
Bailey's done on behalf of the people, Your Honors.
Assistant Public Defender Zach Finu with and on behalf of Mr. Huff, who approaches. Your Honor, we were requesting an adjournment in this matter, and there's also a bond issue to address.
Yes, I will adjourn the matter to the 25th, 2026, 9 a.m. as to bond.
to my attention that while Mr. Huff was in custody after he had been arraigned, he was arraigned on the 23rd. These calls were made on before it's along with two text her listed number. In these calls, I had a couple concerns given that people saying, I need to get out of here, I'm going to lose my job. They won't let me get out. So I had concerns given the nature of these calls. And the fact that there was contact made 3 days after he was arraigned with the victim.
Your Honor, Mr. Huff would admit to this violation. He would admit to calling the witness while he was in custody, or the complaining witness while he was in custody. We would ask to be heard as to bond and or sentence.
All right, Mr. Allen, go ahead.
Your Honor, Mr. Huff does admit to these violations. He was in custody for 6 days from May 22nd until May 28th before he bonded out. During that time, Your Honor, he did not have any of his medications with him. He did not have his blood pressure medication. He did not have his heart medication. So his blood sugar spiked to dangerously high levels. He stated to me that he was not in his right mind. He was it was in a situation where his decision making was affected by his health conditions being exacerbated. So he stated that once he has been out, he has compliant on bond. He's on a tether. He is staying with his stepdaughter, Your Honor, and there's been no tether violations or anything to my that I'm aware of. Additionally, Your Honor, he has these allegations were our office found out about them this morning. I informed Mr. Huff of the possibility of him being remanded today. He did not run. He did not flee the courtroom. He sat right there this entire time, knowing that he could be brought into custody, Your Honor. So he is he's requesting another chance, Your Honor. He understands the nature of these charges and that he will have no contact whatsoever with the complaining witness. I believe she is here as well today, although I don't know that she's going to speak or anything like that. But and then additionally, Your Honor, he is very concerned about losing his job. He has severe health issues. His wife, this is the complaining witness in this case is his wife of 20 years. She also has health issues. She has cancer, is my understanding. And so he is worried that if he loses his job, they will both lose health insurance. And so for that reason, Your Honor, we're at the court's mercy. And then lastly, Your Honor, if you were to remand Mr. Huff into custody, he would be requesting just a day or a few hours so he can go and get his medication so that this situation does not happen again while he is in custody. And then lastly, Your Honor, he has been attempting to go to community corrections and test. He was arraigned over the weekend by Magistrate Wang, and it appears that there was some issue with getting the community corrections test over. So he has been trying to go there. He has been twice. He has called. And as of right now, they stated that they did not have an order. So if Your Honor were to allow him to not be placed into custody, we would request that an order be sent over to community corrections so that he can test. Thank you.
Send this out to the 25th. I don't need any response to that from the people. Depending on having admitted to the violations, I'm going to send it to 10 days. I'll give him credits, but at this time, defendant is removed.
Thank you, Your Honor.
Court calls case People versus Chaz Williams.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Williams, Your Honor. I believe they're bringing him out, Judge.
Oh, okay. Could have waited.
May I approach?
Yeah.
I'm sorry. State your name for the record.
Shag Williams.
Thank you. What are we doing?
Your Honor, I'm asking for an adjournment in this matter. I'm asking for the 18th. I believe he's set to be arraigned by the magistrate today on a charge on a home invasion first that predates these matters, but is still from earlier in the year. I did speak with Miss Anderson from our office who was handling that. And I believe that the magistrate will see him this afternoon. And I think they're anticipating a date of June 18th for that as well. And there is an issue about maybe he did or didn't retain in this matter. I'm going to try and follow up with the attorney who has there's another matter pending in the district court as well.
Right, he does have that happening issue for that's filed with the same victim on 1482. He also has the case off this afternoon that predates the case he is here for right now. That is with the same victim as well. And that is what to be arranged.
All right. Probable cause conference, June 18, 2026, 9 a.m. Bound.
Thank you.
Thank you. Court calls case People versus J1 Jones.
And then on behalf of people, Your Honor.
Assistant Public Defender Davi Luba on behalf of Mr. Jones. Mr. Jones, can you tell the court your name, please?
Juan Jones.
Thank you.
And
What do we?
Your Honor, we do have a green sheet requesting an adjournment in order to review or receive rather the 911 calls in this case.
Quickly address bond.
First. All right. I'll adjourn this to the 18th or the 25th, excuse me. 9 a.m. Yes, that's the bond.
Especially that after this time of the rain on 526 at 6:24 that evening, he contacted the victim. It's very short call. This talks about that he has 4 counts and that would be a jail. And the call is very short call, it's only 1 call. But I do have concerns that he was contacting the victim after he had been arraigned and told not to contact the victim.
And Your Honor did discuss that with Mr. Jones. He will admit to that. What he's explained to me is that he was kind of freaked out. He was calling every number he could think of, just trying to get some information across about upcoming expenses. He understands that that was not the appropriate course of action. He understands that he needs to have absolutely no contact with the witness in this case. I would ask that the court simply admonish Mr. Jones.
There was the 1 call. How long has he been out?
I believe he bonded out fairly recently after it was rain.
Thursday of last week, Your Honor.
And Your Honor, I think Mr. Jones has been in the courtroom long enough to observe what happened.
So he bonded out on the. I have my calendar set up. Thursday of last week's on the 28th.
Yes, Your Honor.
We haven't had any calls since.
Correct, Your Honor. The call to the victim was just on the day he was arraigned at 6:21. So maybe it was pretty much after same day he was told.
And no reports of any additional.
Correct.
How long were you in?
Memorial Day till Thursday. So it was like Monday.
3 days?
3 or 4 days.
Tell me what you think I shouldn't send you.
I'm an upstanding character. I just need a little time. And I'm doing what I need to do to ensure that this will not can happen or continue.
I think you should address what you did with regard to the bond.
In regards to the bond, no contact, that's an order. I understand the severity, and I asked the court and yourself to please just give me a shot, not send me back to jail in regards to making a wrongful decision.
Well, the only thing that sort of cuts in his favor is that there's only the 1 call. He continue as I constantly see repeated patterns of calling somebody.
And I will note for the court that call was only a minute long.
Hey, John, I think
I kind of believe what he's saying, that he was freaking out. He just calling folks. Probably not the call you should have made. Young man, I'm going to give you a break. I'll take the admission to the violation. I'll send you the 3 days credit, 3 days that you served.
Thank you, Your Honor.
Thank you, Your Honor.
20. So. Court calls case People versus Brendan Lathrop.
Morning, Your Honor, bring to the people.
Assistant Public.
Yeah, I'd rather just call it now. I all the time, but I actually haven't been.
Assistant Public Defender Jay Bellinger on behalf of Mr. Lathrop, who should be in appearance via Zoom, Your Honor.
Yes, Mr. Lathrop, you there?
Yes, yes, sir.
All right, I need a camera.
It won't turn on. It says the host disabled it.
Oh, that's because you were smoking. Yeah. What? He apologized? All right. Pardon? Yes, all right.
Your Honor, my understanding is that he's here to be arraigned on 2 additional charges as
So wire or possession by a prohibited person of firearms, and then that's count 3, and then the count 4, possession by a prohibited person of ammunition.
As to those, Your Honor, we will waive formal reading, stand mute at this time.
Defendant arraigned and stood mute. Two counts, 3 and 4. Court will enter a not guilty plea.
Thank you. And as for the PCC today, Your Honor, we are requesting an adjournment for the time being, so I have an opportunity to again try and appeal to Mr. Cook's better senses.
Wow, that was kind of rude.
I don't know if I have.
You do. You do. He does.
Okay. Probable cause conference will be adjourned. I'll adjourn it out to June 25th, 2026, 9 a.m. Bond will
Thank you very much, Your Honor.
Thank you.
Thank you, Your Honor.
Oh, you know,
Oh,
They haven't read. Court recalls the case People versus Heath.
I'm sorry. Yeah, no problem.
Ready, Judge. Court shall feast first assistant public defender appearing with Mr. Heaton on file number 26F30532. That look right to you, sir? That's the case number you want me to talk about, right?
This is the one, work next to the information.
You know information. That's the case number right now. Okay. The right one, right? That's the right case number? Okay. State your name, please, for Judge.
Justin Heaton.
Thank you.
Thank you, Judge. I did have an opportunity to speak to Mr. Heaton back in holding. We had a good. Mr. Heaton wanted me to appear briefly and ask the court for my appointment temporarily. I told him that it's not generally how it goes, but he said he'd like me to help him through today's hearing and then go from there, Your Honor, if the court will allow.
I will indicate this now a public defender case.
Thank you, Judge. In speaking to Mr. Heaton, he wanted to make sure which case number he was here on, and that's why I read that case number.
Number
Yes, Judge.
0532 case.
Okay.
All right.
So that's the case number that we're here for, Mr. Heaton. He has indicated, Your Honor, that he would like the court to consider amending his bond information and the court paperwork, he says, so that the court may consider releasing him. Today is what he wanted me to request, Your Honor. He said that he has no problem addressing this case, but he'd like to do it from home and not from in custody. I spoke to Ms. Feltis about this briefly, and I believe she indicated that the people were contemplating moving for a competency evaluation for Mr. Heaton. I discussed that with Mr. Heaton. He said he has no problem doing a competency evaluation, but he would prefer not to have to do it while in custody. So he wants the court to consider his release.
Okay, so quite honestly, I don't think opposed to his release, but I'm not going to do it today.
Okay.
Okay. What I will do, instead of adjourning it out 2 weeks, I'll just adjourn it out 1 week.
Okay.
And then I'll continue as bond. And what I would like to see is potentially that but I'll have my staff provide the name of the attorney for the trust that basically owns the house that this individual lives in.
Okay.
Okay. And so somehow or another, and what I was trying to explain to Mr. Heaton, that case is before me on my
Civil side.
landlord tenant docket.
Okay.
So while I don't oppose that, I know there would have to be conditions regarding his release back to his home. So hopefully we can get that all worked out, talk to the council for the Heaton Trust, and then we can get him out of custody in there. And back home.
Thank you so much, Judge. Mr. Heaton, do you understand what the judge said?
Well, I have a question.
Okay, please.
So the conflict is in the location rather than this current case.
The conflict, what do you mean?
The conflict that we're looking at does not pertain to case 0532 or
I'm not sure what you mean by conflict, but I'll just say this. I'd like to get you back home to your home in Chelsea, right?
Well, that's not where I was apprehended.
Pardon? That's not where I get that's not where you're apprehended, but that's where you live. Right? And so I'd like to get you back where you can reside there. But I know that there are impediments between the homeowners association, the trust that owns the condo, and then you're residing there. I know that those exist. What I'm hoping is by giving them the number to the
trust attorney,
that some of those issues can be resolved, and then you can go back there under certain conditions.
But
all right, so that's what I'm going to do, and I'll just put it out a week, and let's do that, and I'll make sure you have those numbers.
Thank you very much.
All right, thank you.
You can go, deputies.
That's the last jail.
That's the last jail. Guys, thank you. You'll pass along the information I was giving to Mr. Okay. Courthouse case people versus Robert Lowry.
Morning, Your Honor, Raymond Cook for the people.
Pretty good, Judge. Court shall feast the first assistant public defender on behalf of Mr. Robert Lowry.
Mr. Lowry, state your name, please.
Robert Lowry.
Thank you, Judge. I believe you should have some paperwork on your file for a waiver. My understanding is that Mr. Bellinger negotiated with the circuit court attorney for a HIDA resolution at circuit court, and that we are requesting to waive this matter for that resolution.
From the people's perspective, is that correct?
That is correct, Your Honor. My understanding of the offer was to waive and plead as charged under HIDA with an agreement that the defendant undergo alcohol screening and assessment and complete any treatment as ordered by probation.
All right. Mr. Lowry, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand that?
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
July 1:30 with Judge Cummings.
July 28, 2026, 1:30.
26 or 28?
July 28, 2026.
Okay, sorry. Thank you, Judge.
Thank you, Your Honor.
Bond. Thank you. Bond, continue.
May I approve to send the information?
Yes. Court does call the case, People versus Cheryl Bodger.
For the people here. Public defender. Tonight, I can really, Your Honor, on behalf of Ms. Monster, who's on Zoom, just.
Yes, she is. Ma'am, get yourself unmuted and state your name.
Carol Mager.
Major, okay.
Your Honor, we have not been able to establish contact with Ms. Mager, but I did receive a message from our office this morning that she reached out to the office, so we need an adjournment.
Probable cause conference in this case will be adjourned to June 25th, 2026, 9 a.m.
Can you ask her to, for contact info,
With the office.
please?
Margaret, can you call the public defender's office and leave a good phone number and email for you? So,
I don't have any phone number. I mean, I have a cell phone, but it's not activated.
okay, ma'am, let's do this. I'm gonna move you virtually. I know that sounds weird. Into a breakout room with somebody from the public defender's office so they can get information on how to contact you, okay? Ms.
Okay.
Mager?
Yes.
Okay, right.
Okay.
I've got. Who?
Christian.
Oh, she's available. Okay. Okay, we're gonna put you in there and you come back and see me on the
25th.
on the 25th. Okay?
Okay.
All right. Thank you. Fine, we'll continue. You got it.
Yep.
Court calls case, People versus Eric Mayfield.
People.
Ashley Hannibal for Mr. Mayfield, who I believe is joining over Zoom.
Yes.
All right.
Mr. Mayfield, state your name, please.
Eric Mayfield.
Thank you. All right, what are we doing?
What I have here is that we are ready to make a plea deal.
Should be a signed copy of the plea form in your file, Your Honor. The defendant is going to be pleading guilty to an added count 3 of controlled substance use.
Negatory ghostwriting.
Oh, the pattern is full, Your Honor. All right. Not sure what happened.
Mr. Mayfield?
Yeah.
Go ahead. Hang on a second. What are you doing, Lebo?
This is Fleischer Davi Lebo. I did send the plea form in yesterday with an advice of rights. I'm not sure why it wasn't received. I can resend it.
1 second, bro.
I attempt sent someplace else.
Essentially, yes, Your Honor.
Yes, okay. All right, Mr. Mayfield, we didn't get your paperwork, okay? So I'm gonna put you out. I'm gonna put you out 1 week, bring you back, paperwork will get here, and then we'll be able to take care of your matter, okay?
Thank you, Your Honor.
You got that, Mr. Mayfield?
Yeah.
Okay. June 11th, 2026, 9 a.m. or as your invite indicates, bond continued. All right. Thank you, Mr. Mayfield.
Waited all that time.
Thank you, Your Honor.
Court does call the case, People versus Desmond McCaster.
Good afternoon, Your Honor. Agreement book for the people.
Good Judge, Court shall Fleischer Special Assistant Public Defender on behalf of Mr. Desmond McAllister.
Callister or Caster?
Caster? I haven't had a chance to ask him, Judge.
You guys are close.
Oh, he's here.
All right. He's here.
Great.
Sir, can you unmute and state your name? So Mr. Fleischer know who you are.
Desmond McCaster.
Thank you.
Great to meet you. Judge, we'll be requesting an adjournment so that we can have a chance to speak to him. The number we reached out to but we're not able to have contact.
All right. I'll adjourn this out June 25th, 2026, 9 a.m. Mr. McCaster, do you have the number for the public defender's office?
Yes.
Okay. Call them and just make sure they have a good phone number and email for you, okay? I need that right
Okay.
away for me. Okay?
Okay, will do. Okay.
All right. Thank you, sir. We'll see you on the 25th.
Okay, see you.
Court calls the case, People versus Deshaun McFarland.
Good afternoon, Your Honor. People.
Assistant Public Defender Davi Lieba on behalf of Mr. McFarland to appear to advise him. McFarland?
Deshaun McFarland, Your Honor. Good afternoon.
Good afternoon, sir.
And Your Honor, we have reached an agreement in this matter. We just need to finalize some details regarding the return of some property.
Okay. Would you get that done by the 18th, you think? Or you need more?
Difficult reaching the victim to find when they'd be able to come in and facilitate that. If we could get, that would be preferable, but I understand the court can only.
No, what day would be good for you guys? I mean, would 25th or the 2nd work?
I'm hoping the 25th will work, and certainly by that point, if they're not reaching out to us, we might just be setting for exam at that point anyway, so.
All right, well, let's do this. Let's give you the time to get it done, hopefully. So July 2nd, 2026, 9 a.m.
Thank you, Your Honor.
All right. Thank you, Mr. McFarland.
Thank you, Your Honor.
Court calls the case, People versus Michael Magaha.
Assistant Public Defender Tanazi Carrie Rudy on behalf of Mr. Magaha, who's approaching. Record, sir.
Michael McGaha.
Thank you, sir.
How you doing? Oh, I'm sorry. Work habits.
For an adjournment today.
Of course you are.
Yeah, one of those days. I don't have my green sheet.
He doesn't have, what? She got green. What's the one in your hand then?
I don't even know who this is, Joe. That's Dobby's, right? Yeah. Oh, that's Betty's. That ain't it.
Come up, Mrs. Earlier, Judge.
This ain't done.
June 25th, 2026, 9 a.m. Get the green sheet. Get it.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls case, People versus Don Mitchell.
Ready Judge Torshio Feaster, Assistant Public Defender on behalf of Miss Dawn Mitchell. She should be on Zoom.
Can Zoom? Don Mitchell? Nope.
Oh, well, that's great. We spoke to Dawn Mitchell. Yes, Judge.
How'd this go?
Apparently not well.
Okay.
Someone turned on the camera, Judge. Is that her?
I don't know.
That's her, according to
See,
Miss Zinda. That's her.
that's her.
Thank you, Miss Zinda.
Miss Mitchell, can you unmute?
I see lips moving, but no words, Judge.
Is
Okay.
it there now?
Yeah,
Can you hear
are
me?
you Miss? What's your name?
Dawn Mitchell.
Thank you.
Thank you, Judge. We did connect with Miss.
In this courtroom, a man asked the judge for permission to have contact with his wife again. But as the case unfolded, the judge discovered something disturbing. Years earlier, the defendant had already been convicted in a similar burglary case involving a woman he claimed to love. Now he was back in court after another violent incident. Prosecutors described allegations that he forced his way into a home, assaulted the victim, and then fled the scene. The judge wasn't convinced that enough had changed. He pointed out a troubling pattern and reminded the defendant that hurting the people you claim to love is unacceptable. Despite progress in counseling and probation, the judge refused to lift the restrictions and ordered continued supervision. Then the courtroom shifted to a major criminal trial, where forensic experts explained how gunshot residue evidence could help uncover what really happened during a shooting.